Thank you. First, I want to thank the Graduate School for allowing the legal office a little bit of time. We believe the best way to avoid lawsuits is to teach our faculty members and graduate teaching assistants some of the legal issues. So I'm passionate about this. I've been with the University of Alabama system 24 years now, and I love this stuff, and I understand that you all may not. You're here because you're passionate about the area that you teach in, but I'm going to just ask you to bear with me. It's a long hour. We're going to fly through some law here, but it's really to help you, one, spot some legal issues, and two, for you to know then who to go to at the university to help you when you see one of these issues. And I've got to kind of acclimate myself here for a minute and see where I can do this. Here we go. All right, so the policies that we're going to cover today are generally in the harassment, and that can be based on any protected category. We'll talk about that in a minute. Students with disabilities, we're going to talk about what do you do when you get that letter from the Office of Disability Services. And then we're going to talk about, and I heard from Dr. Schmidt that somebody mentioned that FERPA word. FERPA stands for Family Educational Rights and Privacy Act, and it's just our acronym for that law, passed in the early 70s, and that is what keeps student records, including your student records, because you're in that dual role. As a graduate teaching assistant, you're our employee, but you're also our student. So this law is important for you to know, not only because you need to help us comply with it, because you're our agent when you're acting as the teacher, but it's also your right. And so we're going to talk a little bit about the policy on confidentiality of student records. I said see handout with important policies, and I want you to flip right now. I am in the green section of your notebook, and if you flip to page 40, this is something new I did this year because we have so many regulations that we have to comply with, and it sometimes gets overwhelming, and I want you to realize what you have in your notebook so you can go back to it later. Just real quick, we've got a website for where you would report criminal activity that we have to report crime stats. I'll talk about that in a minute, but that's my first policy. Title IX policy, and I'm going to ask Beth to stand up here just for a minute and turn around and wave. This is Beth Howard. She is our Title IX coordinator. She is a lawyer. She has been here a few months. Her job was created maybe a year ago to help us look at gender discrimination issues systemically, and she is the key person that if we have a gender discrimination, whether it's harassment, sexual assault, just any kind of gender related or sexual misconduct, she's a key player. And I wanted you all to see her, and if afterwards, or if you want to contact her for questions, that's who you need to contact, as well as some of our designated harassment folks. So this website is going to be maintained by Beth. So I wanted you to just put a face with the policy here. Sexual assault policy, we're required by federal law to have a policy, and so I just am getting you to that. This is a big area in the Department of Education. They, if you read anything in higher ed, there's a lot of criticism of universities for not handling claims of sexual violence, sexual misconduct appropriately. So we are spending a lot of time. Beth's hiring an investigator. We've always had designated harassment resource persons, but we want our student population in particular, and mainly, not just, we want all our students, but we know our freshmen coming in are going to be experimenting with new behaviors. There'll be alcohol involved. We want them to know where the resources are that they can go get help. And Beth's got a one-stop shop website, and it's easy. It's Title IX, www.title9.ua.edu. We're going to talk about child protection. The Penn State matter has made this a big issue in higher ed, and so we have our own child protection policy, and there will be some mandatory training that all of you will have to take, and we'll talk about that. The harassment policy, we give you the contact information on that, and we'll talk about that. The link to the Code of Student Conduct, which applies to you, so you could be charged under the Code of Conduct if you engaged in some of the behaviors that are in there, or your students in your class. If they're disrupting your class, you have a right to file a complaint. with our Code of Conduct office, and they can help you go through that process. A lot of times when it's just some disruption in the classroom, we're talking maybe about a behavioral contract with the student. But if you don't reach out and contact that office, there's little we can do to help you. So I want you to know about that policy. Also, hazing hotline. Hopefully y'all won't have to use that at all, but I want you to be aware we have a hazing hotline and how you would make that contact. We're going to talk today about consensual relationship policy, so I give you the direct link. I used to copy all this, and Dr. Schmidt was very kind to pay all that money to print all these policies, but now I'm just giving you the link. It's on the web, but we're going to talk about the consensual relationship. Also, an ethics and fraud hotline. If you're concerned that someone is perhaps using their position, and I don't cover state ethics law in here, but all of us as state employees, myself included, I cannot use my job for my personal gain. So I heard earlier about whether you should pick up another job. If you're an entrepreneur and you're gonna run a business on the side while you're doing all this stuff, you can't do it on university time using university resources. Your faculty members that you're working for cannot use you as personal slave labor, okay? That would be an ethics violation. So they can't ask you to run a bunch of personal errands. And if that is happening and you're concerned, one place, would prefer you just go ahead and talk to a department chair or somebody who can handle it. But if you're nervous about that, that's an ethics hotline kind of issue that we could delve into. We would need a little bit information to go investigate it, but I just wanted you to know about it. Lee Keys, Dr. Schmidt, has Lee been here today? Okay, so you all know about a 911 guide, so I give you the link to that. And then for some of y'all that may take students on field trips, etc., I've given you a link to the risk management website so that you could actually go look at some forms. We encourage you to have your students sign an assumption of risk form if you're going to be taking them, on a field trip outside of the university or whatever. So that's just sort of an overview of the kind of resources that I've given, because there's no way in the amount of time to actually cover all those. But those are definitely important policies for you to know about. Okay, and we're back now, for those of y'all following in the book, we're back on page 17. Let's see. Okay, so you're going to ask, do I really have to sit through this? And I just want you to know that I used some clips in the past, and they were getting dated. And you go, is it really relevant? Is that like the kind of behavior people engage in these days? And so I went and did a Chronicle of Higher Ed and Inside Higher Ed research just to see if, am I just over worrying about this? Surely this doesn't go on college campuses. So in the last couple years, I think everyone knows about the Penn State matter, and that's why we're going to talk about our child protection policy. A GTA observed some behavior, told the next person up on the hierarchy, but didn't go to the police. In the state of Alabama, you're going to be going to 348-5454. That is the UAPD, and if you see anything with a minor, you're going to have to call the UAPD. You do not worry about telling somebody up the chain first. And I think you're going to see a climate change across higher ed across the country. That was a major problem with the Penn State scandal. University of Miami, those of y'all in the philosophy department, this is big in the New York Times, I think, ran an article last week that we had a tenured faculty member, well respected over the years, has submitted his resignation because he was sending his graduate research assistant some very sexually explicit emails and texts. Let's just say, well, there's one in the news clippings that talk about maybe we could have sex over the summer 3 times when nobody's around. So they're calling it in the press the 3 times email. I'm astounded, but I think everybody in the room, raise your hand, do you get that? You know that you're not supposed to send sexually explicit emails, but this is, happening today. Slippery Rock University just fired a tenured department chair who was on spring break trip to Spain and they were out at a bar and asking a lot of sexually explicit personal things about that particular student. University of Iowa, this was an administrator, not a faculty member. They were associate director of athletic student services and director of academic advising. is trading football tickets for sexual favors and inappropriately touching. Come on, do y'all know this? Help me. Everybody understand that's not acceptable behavior. Rutgers, and if y'all are familiar at all, this is just a tragic, tragic case where a roommate, through a little webcam, taped his roommate having sex with another male. Then that went on the internet, and that young man committed suicide, and this man was criminally convicted. It is quite amazing to me what our students are doing today with the technology and how harmful and painful it is. And so I'm just going to encourage you, we don't engage in taping of sex and then putting it out on the internet, whether it's male to male, female to female, male to female. That is unacceptable behavior. And I feel like I'm lecturing, but y'all, this is happening across higher ed. And so I just want to make sure that you all know that is unacceptable behavior. Tacoma Community College, a former instructor was criminally charged for allegedly, this one's great, persuading a voice student that she could hit lower notes if she stripped or engaged in sexual activity while I'm not making this up. I brought the press clippings. Google it and you will see what I'm talking about. University of California at Berkeley, a female high-level person in the chancellor's office was giving her lover tripling her lover's pay, and when she was fired, even though she had been trained 3 different times on harassment policies, she said she didn't understand. So we're going to spend a minute or two on consensual relationships today and how those are inappropriate. So, do y'all agree we really need to be trained? I think, yeah, we got some thumbs up. Thank you. So, what are the consequences of policy violations that I'm going to talk to you about today? You could lose your employment and GTA benefits, and I've got you all signed a memorandum of appointment, and I encourage you to go back and read those. But it basically gives us the authority, the university, the authority to take employment action against you if you violate any of the policies, and that's common sense. I'm an employee at will. I can be fired for a good reason, a bad reason, or no reason at all, as long as it's not an illegal discriminatory reason. And basically, your agreement's the same thing. So we just have to be careful and make sure we don't violate our policies. You could subject yourself to code of conduct, or any student engaging this could subject themselves to code of conduct sanctions. We could invite the Department of Education, the Office of Civil Rights, or on the privacy of student records, there's a group called the FPCO, the Family Policy Compliance Office. Those are all the big Washington, D.C. offices who, because we receive federal financial assistance from the federal government, they can come down and audit us, they can fine us, the worst case scenario, they could take our financial aid and we would have to shut down. So that's the worst case scenario. What else? We could expose yourselves and the institution to civil litigation. And I'll just take a moment right here, because this is always of concern. Are you covered by some insurance policy when you're acting on our behalf? Yes, you are. We are self-insured. The UA, UAB, and UAH, we all put our money into one pot, and we have a self-insurance. So as long as you're acting within the scope of your employment, if you're sleeping with your students, you're not acting within the scope of your employment. If you are teaching and somebody accuses you, even if you did something negligently, we're going to cover you. Thank goodness. I'm covered. I'm going to make mistakes. I'm covered for that. Our office will come in and work with you and defend you. And we have had to defend GTAs in matters before. It's just you don't want to blatantly violate any of these policies that we've talked about, or you will lose your defense. And I can tell you from experience on the consensual relationship policy, if you have a relationship with a student and that student later claimed it was not consensual, I needed the grade, I needed the reference, whatever, and later kind of recanted on the issue of consent, we would not provide a defense to you. You would have to hire your own lawyer, and that has happened a couple times here during my tenure. So don't mess around with this consensual relationship policy, because that could really cost you if it went south. There's obviously you're derailed if you're spending time with me in my office trying to figure out facts versus you making progress with your education and your teaching. So that's another kind of cost of litigation. There's also criminal prosecution, as some of the examples that I gave today of recent cases, and then your own reputational damage. So those are awful consequences. I can tell you we have tons of resources here to help you stay out of that kind of situation, but it's up to you to, again, know to spot the legal issue and know who it is that you need to come and visit with to get some help. Don't try and handle any of this on your own. All right. First of all, we're going to talk about mandatory reporting for child abuse or neglect. After the Penn State matter, as that was unfolding, the university came up with a child protection policy. We weren't required by law to do so, but we felt like, you know, even though under state law there was not a mandatory report at that time for higher ed officials, we wanted to be proactive. So we came up with a child protection policy. I give you the website to that. In Alabama, for the purposes of this statute, a child is someone who's under the age of 18. So if you see or know of any abuse of any of your students or any university student of a child under the age of 18, or it could be a visitor to our campus of a child under the age of 18, then you are, under university policy, required to report that to the UAPD. As of August 1 of this year, just a couple weeks ago, Alabama changed its law and it put into the mandatory reporting category higher education employees, and that's y'all. You are now a mandatory reporter, and if you don't report when you're supposed to, you can be criminally charged. It was a policy until August 1, and now it's a mandatory. So the key lesson here, and you'll have mandatory training, is if you see or learn about any child abuse or neglect of a child under the age of 18, you call 348-5454, and that is the University of Alabama Police, okay? And then let all the other, and Beth Howard may be involved. That's really not your concern. You make the report, and then our process kicks into place. Let me go back on that. You're protected from retaliation for doing that, and our statute gives immunity from civil liability. So the kid can't sue you, or the person who you're alleging did something wrong can't sue you. You're immune from that. All right, so that takes care of the children. Now we have a non-discrimination policy, and I'll just tell you, because this is general, y'all should know this, that we can't discriminate on any of these bases: genetic information, race, color, religion, national origin, sex, sexual orientation, age, disability, veteran status. That's covering all the laws by different designations. We also have a diversity statement, and I encourage you to go look at that online, because we know that you all are going to be teaching some very, some of y'all, math is not very offensive. It would be to me today, but not that kind of offensive. Some of y'all are teaching topics that our kids aren't used to having healthy, respectful debate about. It will be quite offensive to them. And you have some academic freedom interest in how you present that material. But there's a line. We'll talk about that in a little bit on academic freedom. The main thing here that we promote through our diversity statement is that we have respectful dialogue about issues that are very controversial, that people feel very different about. We've got to be able to have the conversation because we're the marketplace of ideas. You all are trying to expose students to a wide range of ideas. So we don't use our classrooms to push one idea over the other. We use them to have that exposure across the whole gamut of the academic issues. We just want to do it respectfully and not pick on different viewpoints. So that's the diversity statement that I encourage you to take a look at. Then I mentioned we have the code of conduct, and I point out in this slide some of the things that relate to harassment. There's a whole lot of other things that can violate the code of conduct, but what I've pulled out: the physical abuse, verbal abuse, threats, stalking, intimidation, harassment, sexual misconduct, coercion, other conduct which threatens or endangers health or safety of persons. It does cover hazing, and Beth is now working with some lawyers in our office and the code of Office of Student Conduct. They've changed their name, Office of Student Conduct, and they're working on revisions to the policy right now just to keep in step with some things that are going on that maybe weren't discussed. A lot of cyber stalking kind of stuff, the internet, taping sex, putting it on the internet. You would think this general category would get it, but we're going to spell it out a little bit better so that nobody can say I didn't realize that that was inappropriate. So be on the lookout. There'll be some language change. On the sexual assault policy, I think the one thing that I want to point out is what's consent. And a lot of times you're going to have two intoxicated individuals, and that will be the defense. Well, we were both drunk, and I'm just going to say that's not a legal defense. If that means the other party was not able to give consent. So I won't spend any more time on this slide because we've got to cover a lot of material, but I think there's a misunderstanding sometimes about what that means. And we have a whole women's resource center that comes out and does training a little bit more on this. If you're teaching a class and you'd like a segment on that, contact Beth Howard and she'll work with you in getting maybe Women's Resource Center. I'm sure she'd be pleased to come talk about that as well. Other examples, and again, these are the kinds of things right now that we're going to be working into the Code of Conduct. You know, photos, videos, or other visual or auditory records of sexual activity made without somebody's explicit consent. It may have been consensual sex, but it wasn't consensual to tape it and put it out on the internet. Dating violence, domestic violence, and stalking. Those are, a law was passed in the last 6 months, the Violence Against Women Act. And we are now going to be required to keep track of that and report that on our annual crime statistics. So we're going to be beefing up and promoting some definitions of what those things are. They're pretty self-explanatory, but we'll be working with Beth and again, the Office of Code of Conduct to work on that. All right, so let's say you have somebody that's sexually assaulted or some kind of, taped sex and then wants to put it on the video. The harmed individual could bring a complaint. Any member of the university community can file a complaint with the Office of Student Conduct. It used to be called Judicial Affairs, so I've got to get used to that, to file anything related to misconduct. So all they're going to ask you to do is put that complaint in writing and then you send it to that office. The head of that is Todd Borst. We don't have a technical statute of limitations, but you all know that the faster we get a complaint, the faster we can investigate it, and over time, we all know our memories fade, the evidence disappears, so we're not going to turn away someone who 6 months after the event has kind of gotten over the trauma of it and comes forward. We don't have a strict statute of limitations, but we are urging students, if you have a complaint, go visit with the Office of Student Conduct as soon as you can, because that gives us a better opportunity to get the evidence while it's fresh and make a determination as to whether it needs to proceed under that particular policy or other policies depending on the conduct. I mentioned earlier the first policy on that list of my policies is Clery Act. This is a law that was passed several years ago, named after a young lady who was killed or murdered at Lehigh University in her dorm. Her parents basically started a whole movement across the country that has resulted in higher education since early 1990 has had to prepare what's called an annual security report. That goes online. We file our crime statistics to the Department of Education once a year for the past 3 years, crime stats. So one of the big things is, are we underreporting our crime? And that's really important. We have always taken this seriously at the university. I've worked with those UAPD since the beginning of this. There's always been a commitment. If anything, sometimes we may over-report. We actually are not required to report the confidential information that comes to our Women's Resource Center, but we think it's important. We may footnote down and say it may not be verified, but we're going to report it because we want our stats to be known and not criticized. But anyways, amongst a list of crimes that we have to report about are assault, sexual assault, domestic violence, dating violence, and stalking. Those are the 3 new ones added this year. Hate crimes, those are just some of them. There is a website that I give you on here that's got a reporting form. You all are not, by virtue of your teaching positions, mandatorily required to report. But if you hear of something that happened on our campus, you could go online and you could print this form. Now, if any of y'all are serving as advisors to student organizations, you are mandatorily required, because anyone who's got significant responsibility for student activities. So they've said teachers aren't doing that, but if you're in any other different kind of capacity, serving as a student org advisor, that will pull you in, and you are required to report that information. So that website gives you the form, and if some of y'all are interested in it, you can actually go through some online training about that. The main thing is call Sergeant Hooks, John Hooks, and he's our Clery Act expert, and he will decide whether something gets reported or not. All right, our UA harassment policy. It used to be the sexual harassment policy, but there was, it's far more than sexual. It covers any kind of harassment that is directed toward another person because of his or her protected status. And we'll have a slide, I believe I have a slide that covers all that. We have a no tolerance statement in that policy. I used to print it, I now give you the website. It defines what inappropriate harassment is. It requires, and we've already covered some examples just through reading the Chronicle. You're supposed to promptly report those. If you are a victim of harassment and you sit on that information, the case law that's developed out there could say that you don't have a cause of action because you were told you have to promptly report and you didn't. So don't be in that situation. If you know of somebody who is being harassed sexually, race, disability, age, gender, religion, any of these protected categories, get that reported. And in our institution, if it's gender, you can call Beth Howard, and she will get you to our designated harassment officer, or you can directly contact the designated harassment officer. These are individuals who are located in all of our colleges, who know a little bit about who's working, and they've all been trained on what to do when a complaint like this comes forward. You want to get in touch with them right away so that they can help you work through that situation, whether you're the victim or whether you've witnessed it. We've actually defended a case in the last couple years where a GTA received some information and didn't pass it on. Now, we were able to work a good resolution to that case. There were other problems for the individual bringing the case, but that was a major concern of mine. Whoa, what happened here? Why didn't the GTA who received that information go report it? So key lesson, if you don't remember anything else I say today, if you hear or know about anything that could qualify as illegal harassment, and I don't even want you to figure out if it's illegal or not, if it's harassing behavior based on a person or group of people because of their protected status, then you need to report it to one of those designated harassment individuals. And I give you the website. You can go to the Title IX website, which has a whole chart on how to report violations, or this website itself is the direct link to who those people are in each college. So if you have a student who is complaining about a criminal justice class, let's just take that out, you would go to the designated harassment person in the College of Arts and Sciences. Okay? If you called the CMBA harassment officer, they would help get the person to the designated harassment officer for Arts and Sciences, because we want it to be handled wherever the offender is. That's where we want the designated harassment officer contacted. And you want to help them get to the right person, because we don't want someone to have to tell their story 10 times, to get to the right person. It's traumatic enough to talk about it. So what we want to do is get them to the right person as soon as we can. If it's gender-based, Beth's a great start. She'll kill me for saying that, but she's going to get you to the designated harassment officer. All right, so I told you it covers all protected categories, and this slide takes you through it. So if someone's directing behavior based on these categories, you report it. It does include, and this has come up in the past, Congress, when they passed all these statutes, never used the term gender identity, sexual orientation, but case law developed as time went on that basically said, well, it doesn't matter if it's same sex. And then more recently, even just as recent as December of 2011, our circuit handled its first case that said, hey, this was an individual who had a job working with the legislature in Georgia who was changing genders and did a great job in the work, but was actually told when she told her boss, who was a lawyer, by the way, I'm changing genders and I think you should know that, and he fires her. Didn't matter that she was an excellent worker. So she litigated that issue, and the Supreme Court didn't have to look at it. The 11th Circuit resolved that in our circuit, that kind of behavior, even though Congress didn't put the words transgender in the statute, you are stereotyping based on what you think a gender should be, and therefore it's illegal. And this one was under the Equal Protection Clause. So I put this slide in. I know Beth's website covers it. Title IX covers this kind of, protects this kind of behavior. And if you see it or know about it, you need to report it. Harm caused by the conduct. What we're looking for, what's going to create the legal exposure is one level, but what we want you to report is a much lower. We know that one sexual joke in the classroom is not going to allow the plaintiff to recover a bunch of damages. The law says it's got to be pervasive. But under our policy, that gets reported because we have investigators who then have to go in and what I call it, nip it in the bud. It's our responsibility to have stopped it. We may send you for retraining if you were the one that engaged in that behavior. So what we are allowed to take action against under our policy is much lower than what a civil case would require a plaintiff to establish. Under Title IX in particular, and that's the gender-based, the question that the Office of Civil Rights is going to ask is, does the conduct interfere with or limit a student's ability to participate in or benefit from the services, activities, or opportunities offered by the school? Notice they don't get into whether it's severe or pervasive. So the experts, the Beth Howards of the world, the designated harassment officers, they're the ones that know if there's any concern at all, you just get it to the right people. Another slide on what are types of inappropriate harassment, but I think we've kind of covered that. I wanted to give you a word of caution about Facebook because this has come up before with GTAs. With all our social media, you all are living like your private lives and then you're an agent of the university. You know, your teachers. What we have seen as creating some problems is when you start becoming friends with your students, or you direct your students to some website, and on that website you've got stuff that your mama would not be proud of that she's exposed to our students. I always say treat your Facebook, if you're directing your students there or allowing them to become your friends, treat it as if it's your classroom chalkboard. Would the university approve of what you're putting on the board? Now, I'm not going to get into, we're not going to trammel upon anybody's academic freedom rights. We're going to talk about that in a minute, how do you balance that. But the sexually explicit or other kinds of inappropriate behavior, you're not protected. If you put that up on your Facebook, direct your students to it and they're offended, and we've had to let some GTAs go in the past because of that. That's just a word of caution for you. Our anti-retaliation policy. So what if somebody brings a complaint and we conclude, you know, that really wasn't harassment based on somebody's protected status, and you're ticked off, it was against you, and you're going, you know what? I've had it with that student. There was no factual basis for that. How dare they? They're getting an F. Anyone see anything wrong with that? Under the law, both Title IX, Title VII, Title VI, every kind of statute, everyone in this room, every employee, every student is allowed to bring a complaint in good faith It does not have to be valid in fact or meet any legal standard. If they bring the concern in good faith, they're protected under the law. We will absolutely not tolerate retaliation. It's actually the #1 EEOC charge in the country is retaliation. It's not race or disability or gender. It's retaliation. Anyone can guess why? We're ticked off. We got accused of something we don't think we did. It's human nature. So you have to really guard against that if you find yourself in that position. And our office works with you, the harassment officers work with you. You cannot retaliate. And as a student or employee, I want you to know if you bring a complaint, you will be protected from retaliation. It is better for us to know about this so we can do something about it. And I've already pointed out the legal stakes are high. We are exposing the university to tremendous financial and reputational damage and just distraction from our mission of educating students. We want to know about this behavior so we can stop it. So, that clear? Any questions about retaliation? Because that's real important. We want people to come forward. So, if you see something, say something. That is the key message today. You've got to report behavior. I've already introduced Beth Howard, and this has her contact information, so we'll fly through that. This is really a cut and paste from Beth's website. And she's even got more on there, but it really is nice. I'm not going to cover each one, but it tells you if this happens, this is who you contact. If this happens, here's the person. So I've kind of told you, but now you've got something in your notebook you're not going to remember 4 months from now. Remember it's in your notebook and go look it up. All right, I mentioned earlier that academic freedom is important, and this is one of numerous cases out there where a professor was punished or disciplined by Malcolm Community College several years ago. He was teaching an English lit class dealing with some sexually explicit literature. The problem is he crossed the line and started asking students about, telling them about his personal sexual escapades and then asking them about theirs. And let's just talk about that in the classroom. He then made fun of the ones that were brave enough to challenge his authority to do that, or that was making him uncomfortable. So the institution took disciplinary action against him. He sued, and obviously, thank goodness, the courts upheld the institution's right to take disciplinary action. And the main point that when it got to the Sixth Circuit, the judges said, you know, students are captive audience paid to be taught and not vilified in indecent terms, particularly when there's no academic purpose or justification. See, he crossed the line. He left the purely academic discussion and made it personal. And that's the line. You're no longer got any academic freedom when you cross that line. If you've got questions about that, by the way, run it by your department chair. What we're going to look at is what's the standard in the department. If everybody lines up in the department and says, whoa, you crossed the line, you're up a creek. So rather than push the envelope as you're developing your course materials now and you think you're in one of these controversial issues that might generate some controversy among our student body, cover it with your department chair, whoever you report to, and go ahead and clear that up front. Don't risk being out there on your own. UA has a policy statement. Actually, this was taken right out of the Department of Education 2001 Title IX regulations. We just basically copied it. Speech or conduct of a sexual or hostile nature exceeds, and this would apply not just to sexual, racial, disability, all those protected categories we talked about. It exceeds your First Amendment protection if it creates that hostile, offensive learning environment, or it unreasonably interferes with that academic performance of the student, and it's reasonably regarded as non-professorial speech, or it lacks that academic pedagogical purpose, okay? It's just not germane. You crossed the line. So it's in our policy statement if you need to kind of refresh your memory. Last topic on the harassment category, and then we're going to move real quickly to disabilities and FERPA. consensual relationships. I already mentioned earlier, you lose the defense. We will not defend you if you violate this policy. But basically, here's it. If you have any authority, I don't care whether it's a grade or a letter of reference, or if, let's say, you're writing your dissertation and you're in a relationship with someone who's not grading you in any class, but they sit on your dissertation committee. Do you think that would be a violation of our policy? Yes, because they have some authority. What about if they have the authority to write you a letter of reference and they're in your department? That's pushing the envelope. So become familiar with this. I tell GTAs, you know, you can keep your notes. I know you're close in age to some of these students. You can keep your, I'm sorry, I just lost our slide. Keep the notes on who the person was that you were so interested in. They're just the love of your life. How can life get away unless you are contacted with this person? Save it. When you have no responsibility at all for that student, you will not have any responsibility. Fair game. We don't have a dating kind of rule at the University of Alabama. We don't get into whether someone's married or not married. We're not the moral police. But we do have to protect the institution and you from a claim of sexual harassment and that issue of consent. And so when all those reporting channels are removed, go for it, you know. Okay, I'm going to ask, are there questions on harassment or any of the topics that I've talked about thus far? Child protection, Clery Act. We've got one over here. Yes. Perfect. Great question. Sometimes I fly through this. When someone comes to us with a complaint, we can assure you confidentiality to the extent permitted by law. Now, if someone wants to come and tell us that we've got this horrible situation and you want us to do something about it, but I can't go and confront the accused without identifying who that person is, then we're in a quandary because I can't do much about it because you're unwilling to let me go confront the accused. We are never going to take punishment against somebody unless we've given them due process. We're a state institution. We have no choice on that. So what that means is Beth may know about a sexual assault. The Code of Conduct folks may know about it. I may know about it in my job, but none of us can talk about it other than in the context of that investigation. So we're going to keep it confidential to the extent that we can. But we're going to have a conversation with a victim about if you don't let us reveal something, we may have our hands tied as to what we can do to help you. Okay? Now, that's a great question. If you want to step out after we leave, Beth will be back there. We can hammer that out more, but I appreciate you bringing it out. We want that promise of confidentiality, but obviously if there's a lawsuit, the lawyers are going to get access to everything. So that's why we say to the extent that we can. We will be punished if you're in an investigation and then you go out and tell your roommate what the investigator talked to you about, you can be pursued under the Code of Conduct or lose your job. That's how seriously we take the confidentiality. I appreciate very much you pointing that out. Other questions on harassment, and then I'm going to fly. Okay, let's talk about students with disabilities. The Office of Disability Services is the key contact office. They're going to be issuing letters of reasonable accommodation, but I wanted to just fly through a couple slides and tell you, okay, so why do we have to do this? The Americans with Disability Act, and long before that, Section 504 of the Rehab Act, which has been in existence since the mid-70s, we know how to accommodate individuals with disabilities because we've had to in higher ed since the mid-70s. But then in the 90s, the ADA was passed, and this is currently what the law says with respect to students. Students with disabilities who are otherwise qualified must receive reasonable accommodations and are protected from discrimination, harassment, and retaliation. Okay, so that's the standard, and everything that has quotes around it, there's like a million cases debating what that is. You don't have to know that, okay? I'm just giving you background. Who determines whether a covered disability exists? I don't do it. I may be a lawyer and can litigate the issue, but I'm not the designated person at the university trained to evaluate medical documentation. The only office on this campus who does that is the Office of Disability Services. Why do I mention that? Because you're going to have a student come up to you and tell you the entire life story and that they've got this disability and that they need this, and if they don't have their magic letter from the Disability Services Office, you are not legally required to provide an accommodation. Okay, so we operate that way. We designate an office, we train the people in that office to make the determination of whether they're qualified, and then they're the ones that determine what the reasonable accommodation would look like. So your job is to provide the accommodation that the Office of Disability Services says you must provide. And you're not to have a conversation with them, as frankly several years ago one of our GTAs who missed this training did, in front of the entire class, questioning why in the world they would need taped lectures, a note taker, in front of the entire class, and saying that was an unfair advantage. We resolved that really, really fast. And she missed the GTA seminar. She didn't even know that that was prohibited. So you don't discuss in front of your other students somebody else's reasonable accommodation. You may get a request from ODS to help find note takers. Work as hard as you can to help them provide that note taker. Call them if you're confused about what's on that letter. Document when you do get that letter. You are not required. These students may pick up that letter, make it through a test, they didn't do as well, and now they want to claim, they want to retake. No, their job, and they're told this, you turn in your letter and then you get your accommodation, and we don't retroactively give you accommodations. I'm really talking about the whole set of slides here as in a big picture. Under the law, if you meet that definition of disability, you have to be otherwise qualified. And I raise this because we are not lowering our academic standards. We are not required to, because they're not otherwise qualified. That also comes up in the context of someone who is absolutely being disruptive in the classroom. You may have an individual with a diagnosis that's hidden. You don't know what it is. It might be a mental health or a developmental disability, autism, or anything on the spectrum, and they're disruptive in the classroom, and they're violating continually the code of conduct. As much as we would love to help accommodate, we are not required to just throw out our code of conduct and you tolerate disruptive, or worse yet, someone threatens you in any capacity. We're not required under the law to accommodate that. So they have to meet the code of conduct. There's a case out there where somebody cheated and said it was because of my disability. Nah, you're not otherwise qualified. You can't plagiarize because of your disability. You have to be otherwise qualified, meaning you have to meet the standards of being at our institution. And by the way, if you do have a student who is threatening you, engaged in threatening behaviors to themselves or others, Lee Keys gave you, I'm sure, some good information. Amelia Bomar is the director of our behavioral intervention team, and we put a lot of resources into attempting to help students and watch, and we have a duty to protect the rest of the campus. So that's a name and a phone number that I give you in case that comes up so that you can make that contact. What are some reasonable accommodations? Well, we have to remove architectural barriers. You might be a note taker. You may be asked to give a little bit more time on a test, modify the way you're presenting the materials. We may ask some of you to turn over your PowerPoint slides. Whatever, and if you don't like that, you have a way to appeal that. But while that appeal is going on, you got to provide it. And that's going to keep us all in compliance with the law as we go through our process. So let's say you do have a disability, they've got a reasonable accommodation. Is there any point in time where we can deny it? And the law says it isn't very frequent. It would either have to be a fundamental change in the program, and a good example of that is somebody says, I just can't pass math, but the core curriculum says you got to take the lowest level math and pass it. Well, we're allowed as an institution to decide for ourselves, that's our academic freedom, what it is that we think would qualify a student. We're not required to change it just because somebody's got a disability for math. There might be another program they could be in, but that's very rare, and it's not really going to involve your judgment. I think what's more common is you've got back-to-back classes, you've got a class you've got to attend, and someone needs time and a half, and you're like going, how am I going to do it? The burden is on the institution. So if you can't do it, you better be working with the people in your department to make sure that you can provide the accommodation the student has asked for. And you're going to have to engage in some dialogue with the student. Hey, I've got back-to-back. I'm not sure how we're going to do this. You know, Disability Services has a testing service. Maybe we could do it that way. Or it could be you call on someone in your department to assist. But one option that you do not have is, ooh, I'm too busy. Why? Because the burden under the law runs to the institution, and we got lots of GTAs who could step in and help you out. So help us by not saying, oh, that's ODS's problem. Nope, it's your problem, and you're our agent that's going to help us solve it. So tips on following ODS's procedures. Don't decide if the student has a qualifying disability or what that accommodation is. That's not your job, that's ODS. Don't provide accommodations until you have that letter from ODS. Please don't discuss accommodations in front of the whole class. We want you to engage in that dialogue with the student, but respect the student's privacy on the issue. Don't ever ask them about their disability. They're going to volunteer it in many instances. That's fine, but you're not to ask. You don't have a need to know. All you need to know is what accommodation I've been told I need to provide. Discuss with the student how you're going to work with them. It's that dialogue we talked about. And then I've got some language in my handout on 8 Q&As starting on page 43. There's some language that we've suggested that you put on your syllabus to make sure, and this is very helpful because later when they say, I didn't know anything about ODS, it's on your syllabus. And believe me, they're going to use that one. They have. I've been here a long time and it comes up every year. You have that on your syllabus, we're covered. So make sure your syllabus has a statement about registering with ODS. Don't ignore the accommodations because you don't buy them. You don't believe that that's fair. You're going to have to work with us. We can hear your concerns, but work with us. Call ODS if you disagree and provide that accommodation, as I mentioned earlier, if you're in that disagreement stage, so we can go on and not create legal exposure. I give you a slide of all the names of the people who work in disability services, so that's for your contact. Okay, FERPA in 5 minutes or less. Confidentiality of student records is important to you individually because you want your student records protected and then you don't want to violate FERPA. The good news about FERPA, unlike everything else I've talked about, the good news about FERPA is a student can't sue the institution or you individually under FERPA. That's good. However, if you breach their privacy, there may be a state tort claim. So FERPA's huge. We can make violations daily unintentionally, and we're not going to be violating FERPA. But the more sensitive that information is, the more careful you need to think about how you're going to handle that information. So let's fly real through it. I think you know reasons why. I give you some websites as to where the policies are, but there's 3 primary rights that you have under this law. A student has a right to review their records. So, folks, if you're emailing back and forth and creating records and you're maintaining them and you didn't really need to, the student would have a right to inspect those records. So if you're emailing about the hot, student and the student learns about it, that student can come to y'all and say, I'd like a copy of all my emails, and you would have to turn over all those emails because they have a right to inspect that. Now, you don't have to keep all those emails. What you want to do is keep records that are pertinent to your grades, etc. But just be aware of that word of caution that could apply to even emails. Students have a right to seek to amend. Yeah, you made an error in the grading. Now we're going to have to change it. They have a right to seek to do that. And the main thing that concerns most of us in the room is students have a right to limit who gets access to their records, okay? So what records are protected under this law? Everything we got that is maintained by the institution and that personally identifies a student. Or even if you redacted their name off, you could put some publicly available information together with that information and that would identify the student. If it's a record I don't care if it's electronic paper, if it's a record maintained by the University of Alabama and it could be used to personally identify a student, it's FERPA, it's protected. The key point that I want y'all to think about is every day you're gonna have conversations with your students. That is not protected. What they told you, what you personally observed is not sitting away in a record. So if mom and dad call you and it's a small class and you know who's been there or not, and mom and dad wanna know, has Sonny been to class, and you know without looking at a record, you can tell them there's no FERPA anything. It's personal observation and recollection. You have no record that you had to resort to. So sometimes as you're thinking about, gosh, somebody said something to me that's really making me think they're suicidal, don't worry about FERPA. For other reasons too, there's exceptions for that, but that is not a record. You heard it from their mouth, or they're threatening somebody. There's no FERPA protection. That was Virginia Tech's problem a few years ago. They thought they couldn't talk to each other at Virginia Tech and share information. So make sure you understand that principle. When we all go to the doctor, what we say to our doctor is covered under HIPAA, and that conversation is confidential. When we go see an attorney for legal advice, that conversation itself is protected. Why? There's good policy reasons. Can anyone think of one reason why what a student says in a higher ed institution should be kept confidential? There's none. So don't get too concerned about breaching FERPA because you're wanting to report something somebody said. So what are some general rules if you are dealing with a record? Anytime you get the student's consent, this will come up more often when you're asked to write a letter of reference. If they give you the resume, you didn't have to go to the record to figure out anything about it. Just say, hey, I'll be glad to write the reference. Would you give me your, resume or whatever you're going to ask for? If you're going to go to your record to pull out information to put in that letter of reference, technically you need a consent. It's very easy. I, Susie, give permission to Joe to write a letter of reference and release information from my education record. Sign, dated. Don't take it by email because you need an original signature. But that's how simple the rules are. You just need written permission that's signed and dated. Another circumstance when we can release information without worrying about a consent or other concerns is when it's just directory information. They're a student, they attended from this time to this time, they've graduated, they're this level, stuff that wouldn't hurt anybody. But even in that situation, we give students an option to opt out. And we will put a privacy hold on their record and not release any information, but a student has to proactively request and fill out that form. And now they can do it on MyBama through their student portal. And for you all, I've got a FERPA handout for faculty in the last pages of my handout. On the left side of that front page of the FERPA handout, let me get you that, it's page 46. It's going to tell you how a faculty member can get access to find out, has the student given mom and dad or anybody else permission for access to the record. So the technical way of how you do that through Banner is described on page 46 on that handout. So just know that it's there if you need it. Some of y'all may not have access to Banner, but your departmental secretaries will. When else can records? Well, if you need to call the legal office, you can talk to me about the student because I need that information in performance of my job. If the athletic department calls you and some of those advisors in the athletic department need to talk to you about how a student athlete's doing, you get to tell them. There's an exception for school officials who have a legitimate need to know. If you're going to call Beth about an issue, you don't need the student's written consent. She's trying to do her job. So any of us who are legitimately needing that information gets the information. Again, major problem with Virginia Tech a few years ago. They didn't realize that student affairs and police and everybody could talk to each other and not be violating FERPA. We got way too concerned about that and forgot about common sense. When you are a faculty member, I'll go back on that one side. When you are a faculty member and you do have access, then that means your roommate, your girlfriend, your boyfriend, your family member, they don't get access. And so I worry a little bit about what protections are y'all taking to protect the student information that you have. Don't share your passwords with your roommates. They don't need to have the ability to access other student records. So just exercise caution about that. You're given access, but don't share it. Parents, I've already covered what you personally observe is fair game to anybody at any time. That's not FERPA protected. But let's say they want to know the grades, the test scores. There are a couple exceptions. One, we allow that student to give permission to the parent or anybody else, and I told you where to find that on MyBama. Also, parents are allowed to. They don't have a right, but we are allowed as an institution to give parents access if they claim the student is a dependent on the tax return. I don't want y'all to collect tax returns. That's the registrar's office business, but that is one exception. So I don't encourage you to have that conversation with the parent. What I think, when a parent calls and you don't know whether the student's authorized, I would, one, see if you can figure out how to do that through Banner, or two, politely tell the parent, we've got this federal law, I really want to talk to you and thank you for calling, but I need to first get your student to fill out this release of information. Get it to be a partnership between the parent and you and the student, but push that responsibility back on the student and be as polite as you can, because these are the folks paying the bills. Most of them, 99% of them, we would give it to them if we had their tax return. It's just going to be a whole lot easier to have that release done. So we believe, and the studies back this up, that the more connection there is between a parent and a student, the higher the retention rate. So we are all about facilitating that cooperation. And I know that I am out of time, so let's, health and safety, I've already pointed that out. Anytime we have, if you are debating at all about a particular health and safety, you're worried about they're anorexic, they're not eating, they look like they're about to die, and you're concerned and you want to have a conversation, I'm going to tell you, I don't want to face the negligence lawsuit for suicide or some serious, I'd rather you push the envelope on FERPA and protect us from the tort claim. It's just common sense, but the law actually has built in a good health and safety, and they're not exception. And they're saying, if we think there's a health and safety exception and we record what that is, and all we have to have is a rational basis. We may be wrong, but we had a rational basis for thinking there was a health or safety. We're good to go, and they're not going to second guess us. And this was a huge change in the law after Virginia Tech. So you ought to feel a little comfortable with that. So let's say it is a health and safety, so who can we tell? In the regulations themselves, I pulled out everything the regs say, and parents are included in that. And so if we think a parent can help us resolve a health and safety, we're going to tell them. So that's what I had today. Thank you. Y'all paid attention.